State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. The jury is not seated. The state moves to limit the examination of Jason Poirier so that certain acts cannot be inquired into on cross-examination. The state contends that the acts are either not probative of character for untruthfulness or are otherwise inadmissible under Rule 403. The state's motion is governed by really three provisions of the rule: Rule 608B, Rule 608C, and Rule 403. 608B provides that specific instances of conduct of a witness for the purpose of attacking or supporting the witness's character for truthfulness or untruthfulness may not be proved by extrinsic evidence. They may, however, in the discretion of the court, be inquired into on cross-examination if probative of truthfulness or untruthfulness. Rule 608C casts a much broader net. It provides that bias, prejudice, or any motive to misrepresent may be shown to impeach the witness either by examination or by evidence otherwise adduced, meaning extrinsic evidence. Finally, both rules are covered by the Rule 403 umbrella, which provides that evidence, the probative value of which would be substantially outweighed by the danger of unfair prejudice, confusion of the issues, or undue delay, or cumulative evidence would be inadmissible. As to some instances of conduct by Mr. Poirier, the defendant does not intend to inquire into those instances of conduct on cross-examination and therefore does not oppose the state's motion. These include the fact that the witness's toddler was in possession of illegal drugs, certain unspecified threats against Mr. Howard, the witness's landlord, the witness's domestic violence charge, the witness's attempt to exchange firearms for rent, and unspecified lies of the witness purportedly told to his wife and for which the witness apologized. As to each of these instances of conduct, the state's motion is granted. Turning to the other instances, the fact that the witness faced serious probation violations pending against him is highly probative of his motive to misrepresent. The defendant may ask the witness whether he had probation violations alleged against him, whether the violations were serious and non-technical in nature, and whether they had resulted in a recommended revocation of his probation and one-year sentence. Reference to the precise nature of the violation is not highly probative and would ultimately suggest decision about the witness's credibility on an improper basis under Rule 403, an emotional one. No questions about the nature of the probation violations, specifically the guns and knives, will be permitted unless the witness denies that the probation violations were serious in nature, and then the nature of the violations is may be introduced. The state's motion is granted as to non-specific lies to the probation officer. This really cannot be offered. It's not a specific instance of conduct. The probation officer may be called to testify as a character witness, but I don't believe her general conclusion about character for truthfulness would be admissible under Rule 608B. It may under 608A. As to the selling of steroids, this can be inquired into because it demonstrates bias, prejudice, and motive to misrepresent. The fact that during the period of cooperation, the witness openly discussed this conduct on a telephone that he knew was monitored by police or jail personnel demonstrates that the witness believed himself above the reach of prosecutorial authorities because the state needed his testimony in this case. And I'm not persuaded that that would be otherwise inadmissible under Rule 403. The defendant can inquire into the fraudulent obtaining of prescription drugs from Dr. Moore. This is probative of character for truthfulness and not otherwise inadmissible under Rule 403. The defendant can inquire into a fraudulent scheme to buy the house with a present intent to back out of that transaction at the last minute. The purchase of real property is a significant financial transaction, and misrepresentations in that context is highly probative of character for truthfulness or untruthfulness, and that testimony would not otherwise be inadmissible under Rule 403. I will grant the state's motion as to the witness directing his wife to omit telling the LDS bishop about his incarceration in order to secure financial support. A family in financial distress may seek out relief, and misrepresentations under that sort of under those circumstances of duress are not highly probative of truthfulness, and intentional misrepresentations to an LDS bishop would cause the jury to judge the credibility of the witness not on a proper basis, but by a revulsion for that decision. The state's motion is granted as to moving a car to avoid repossession. People routinely take misguided efforts to avoid creditors. It's not highly probative of character for truthfulness. The Rolex watch scheme, the motion is denied. The defense may inquire as to this alleged scheme. Police reports exist demonstrating some evidence on which a reasonable jury might conclude that the witness committed these bad acts. They are highly probative of truthfulness. It's a fraudulent scheme, and that probative value is not substantially outweighed by a danger of unfair prejudice. Finally, as to the sexual battery charge, the state's motion is granted. This occurred many years ago in 2008. The fact that the witness tried to circumvent a protective order is not probative of truthfulness or untruthfulness. It's at this point unclear the degree to which deceit was actually used in facilitating that violation, whether the protected person was or was not complicit with the arranged meeting. Eliciting these extrinsic facts will only confuse the issue and delay these proceedings. The jury is likely to be inspired to hostility toward the witness and judges credibility on an improper basis, namely the general aversion to a sexual battery charge. Therefore, this inquiry is inadmissible under Rule 403. You need time to meet with Mr. Poirier.
I do, Your Honor, and there's one matter given the court's ruling under 608B. I can't tell if it's B generally or B2, but when it comes to the American Fork Police Department issue, Mr. Poirier may need to be advised about his right not to incriminate himself. That is a case that
I was under the impression that you had declined prosecution.
it was referred back to American Fork Police Department for further investigation. My saying, that was done on Christmas Eve last year. Usually we get reports if they're going to follow up on it. We have not gotten reports. That doesn't necessarily mean they're not going to follow up on it.
And the statute of limitations hasn't run?
No, this is conduct that was committed last year. It's a felony, so it'd be well within the statute.
Who represents Mr. Poirier?
He has been represented previously by Ms. Gonzalez of the Public Defender's Office.
Where is he? Is he here?
Poirier?
Yeah.
He is, yeah, he's present.
How would you like to proceed? I can advise him, but he may need to speak to legal counsel about that issue.
What's that? Your Honor, Mr. Grunender is suggesting that the court will give us a minute to call the Public Defender's Office, and maybe Ms. Gonzalez will be available, or someone to advise him right now.
Yeah, I think there's wisdom in that. Is there a witness we can call to get going? What about the other inmates?
Do you want to do it? The problem is, Your Honor, I would be examining the next witness also. That's
you have other counsel here that can summons the
public defender.
so let's get going then.
Okay. State will call inmate number 2.
Go back on the record in the matter of State of Utah versus MacNeill. Mr. MacNeill is present with his counsel. The state's attorneys, with the exception of Mr. Peed, are present. Are you prepared to go without Mr. Peed today?
Yes.
At this point? Very good. The jury is seated. You may call your next witness.
Thank you, Your Honor. Now the state calls inmate number 2.
Thank you. Sir, if you would stand at the witness stand, raise your right hand as best you can and be sworn.
You do solemnly swear that testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please be seated. You may.
Okay, thanks for being here today. We've discussed this before. We're going to refer to you today as inmate number 2, okay?
Yes, sir.
I'm going to ask you also to make sure that, if I may approach, Your Honor.
You may.
Adjust this mic for you so make sure we can hear you.
Okay.
Thanks. You are apparently in custody right now.
Yes.
Are you presently imprisoned?
Yes.
What for?
Conspiracy to cocaine and marijuana.
Okay. And is that in federal prison?
Yes.
So have you been convicted of felonies?
Yeah. Yes.
More than one?
No, just that one.
Just the one?
Mhm.
Okay. Have you spoken to investigators about Martin MacNeill?
Yes.
How many times?
Twice.
Okay. Do you recall when the first one happened?
No, but they went to go visit me over there.
Okay, the first time was the time they visited you?
Yes.
Was that earlier this year?
I think so.
If I said it was in January, would that sound correct?
Yes.
Okay. And the second time you spoke to an investigator, when was that?
When I showed up over here.
Okay. Let me ask you this. Did you ever have a phone conversation?
Oh, yes, yes. I'm
Okay.
sorry.
Do you recall when that was?
No.
Was it earlier this year as well?
Yes.
Was it before or after the interview when they went to visit you?
After.
Okay. So if I told you it was February of this year, would that sound right to you?
Yes.
Okay. Do you know Martin MacNeill?
Yes.
How do you know him?
He was my cellie.
Okay. And when you say cellie, what does that mean?
We lived together in the same room.
Okay. Were you cellmates?
Yes.
All right. When was that?
I don't remember the years. It was 2 years that we were together.
Okay, about 2 years. Okay. And let me clarify, because I think I just misspoke. You were together for 2 years. You're not saying it was 2 years ago.
No.
Okay. You don't exactly remember when.
I don't remember the years.
Okay. How did you meet? Well, let's strike to that. Did Mr. MacNeill have a nickname?
Yes.
What was it?
Doc.
Why did people call him that?
He was a doctor, I guess.
Okay. Did he help people out with their medical issues?
Yes.
Did he ever help you?
No.
Okay. Did you get along with him?
Yes.
From what you observed, did he get along well with others
Yes.
Okay. Did Doc ever talk to you about having cancer?
No.
Did he ever say anything about having MS?
No.
Did you ever notice whether he had a limp?
Nope.
Do you recall telling an investigator earlier this year that he had something like a hip limp?
Used to see him limp, but I don't know if it was a hip limp or,
So you don't know the cause,
yeah, I don't know the cause.
but have you seen him limping?
Sort of, kind of, sometimes.
Okay. Do you know why he limped?
No.
Did he ever talk to you about a toe problem?
I know he had a toe problem, but he never told me what was the problem.
Okay. He never told you exactly what it was?
No.
Did you ever see his toes?
Yes.
What did they look like?
They're like curved to the bottom, towards downside. And his big toe was bigger than normal size.
Okay. Do you recall which foot this was?
I don't remember.
Okay. It's been a while?
Yes.
Your Honor, for the record, when he said his toes were curved down, he kind of made a downward curve with his left hand, fingers. So the toes weren't lying flat, curved under?
Yes.
Okay. Did his toe, from what you could see, did his toe problem ever stop him from lifting weights
No.
or from running?
No.
Okay. Did Doc ever talk to you about his love interests?
Yeah.
What did he say?
He had a wife, and I guess he used to write back and forth with her. He said she was in prison.
Okay, so he talked about someone he wrote letters to,
Yes.
someone who was in prison,
Yes.
clearly alive.
Yes.
Okay. Did he ever tell you her name?
Yeah.
Do you remember what he said?
I think it's the name Gypsy, something like that. I saw letters that he used to get back and forth.
You saw some of his letters? Okay. Did you read his letters?
No.
Oh, okay. You just saw her name?
An envelope.
Okay. But he referred to her as though she was his wife.
Yes.
Did you ever find out whether Doc had a wife who had died?
Later on,
Okay. When was the first time that, well, let me ask you, did you ever talk to Doc about that?
not before that. I mean, after I found out that he had a wife that had passed away.
Did you talk to him then?
Yes.
Okay. Do you recall when the first time was that you talked about this?
No, I don't recall the date.
Okay. What were the circumstances?
It was one day that I guess he came in and he looked
I'm going to stop you real quick. He came in where? Where?
into the room where we
Okay.
were staying at. He looked kind of serious, like scared. And I went out and came back. They were talking about him being on TV. He had been on TV that he supposedly had murdered his wife.
Okay. So when you say he came into the room where you were at, is this cafeteria, rec
No.
room, cell? Where is this?
It's a cell
Okay. And where were you?
in my bunk, my cell, my bed.
Okay. And he came back, he was upset?
He was serious. Like
Oh, he was
had-
serious. Okay, I'm sorry. Did you ask him what was going on?
When I came back, I did because I had heard rumors that they were saying that he was on TV that he supposedly he had murdered his wife.
Okay. When it comes to the TV at that time, did you see what was on the TV?
No.
Okay. But you just heard talk around the
Yes.
room? So what did you do after you heard the talk?
I asked him. If it was true because they were saying that he came out on TV and
Why did
Yeah,
you
they
want
were-
to know?
huh?
Why did you want to know?
I was just curious.
Okay. Okay. Sorry, go ahead.
And he just mentioned that they couldn't prove it. That medication that she was taking, giving him was prescribed.
Okay. Did he say whether he did or didn't kill her?
He just said they can't prove that it was me.
Okay. Did Doc ever say anything to you about his dead wife having surgery?
Yes.
What do you recall him saying? I'm sorry. Let me strike that question and ask a different one. When was this that you had this?
That was later on after that, like maybe a month later or something.
Okay. What were the circumstances? How did this topic come up?
I was just being nosy. I mean, I was just trying to ask him questions.
Okay. And what did he say about that?
He said his wife had plastic surgery, and then she had passed away, had a heart attack,
Okay.
passed away.
Okay. So earlier he said there's some about the medications they were prescribed. Nobody could prove it. This time he's talking about a heart attack?
Yes.
Okay. What did he say about evidence related to the heart attack?
He said there's no proof that it wasn't him. They couldn't prove it.
Okay. Do you recall saying anything about to investigators about doc telling you that the medication was undetectable?
Yeah, 'cause he said it was, I guess it was prescribed, that they couldn't, I guess that's what he meant.
Okay. Do you recall exactly what he said?
He said,
I'm confused.
Your Honor asked and answered.
Well, I'm trying,
Sustained.
okay, we'll move on. I was trying to clarify between what doc said and what inmate number 2 concluded, but,
You can ask that question. I
Okay.
didn't understand your question to be that.
okay. Let me ask you a better question. What did doc say to you versus what is it that you kind of understood him to mean? That's a bad question. I'll move on. Did you ever see anything about doc on TV?
later, within time, like here and there clips.
Was doc still there with you?
No,
What did you see?
they were showing stuff about
Objection,
his,
Your Honor. Relevance. Doc is already gone.
I'll wait for rebuttal on that
Okay.
till his truthfulness has been challenged. Go ahead.
Sure.
Sustained now.
If I could have one moment, Your Honor.
You may. Thank you. You may cross.
No questions.
Do you have any questions for inmate number 2? Pass them to the end of the row. May inmate 2 be released from his trial subpoena?
Yes, Your Honor.
You may step down, sir. Thank you.
Could I have a moment, Your Honor? Check on.
You may.
Released him from his subpoena. We have no objection to that we would move.
No objection.
No objection.
Inmate 2 is released from his trial subpoena.
Mr. Poirier's counsel is present and is currently advising him, but she requests a 5 to 10 minute recess to allow her to
Do you
advise him
intend,
fully.
do you intend to call any additional inmates today?
We we had one more that we didn't intend on calling today, Your Honor.
Yeah.
Are they here? Can we take that witness?
I believe he is here. State would actually move to call Jeff Robinson prior to that, Your Honor.
Okay. How long will you be with Mr. Robinson?
Can I have a moment, Your Honor?
Right.
We can call Jeff Robinson.
How long do you think you'll be with him?
I may be 20 minutes with him.
I don't think I'll be too long.
Very good. Mr. Robinson, if you'll come up, please raise your right hand and be sworn.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
If you'll be seated here and respond to council's questions.
Good afternoon, sir.
Good afternoon.
Will you please state your name for the record and spell your last name?
Jeff Robinson, Robinson.
And Mr. Robinson, how are you employed?
I'm employed with the Utah County Attorney's Office with the Bureau of Investigations.
And what is your position there?
Chief Investigator.
And how long have you been chief investigator?
Just over 10 years.
How long have you been with the Utah County Attorney's Office Bureau of Investigations?
About 20.
About 20 years. Can you describe for the jury just briefly your role as chief investigator?
My role is I am over a number of investigators administratively. I also carry a full caseload. Primarily, I'm involved in investigating financial fraud, officer-involved shootings, political corruption, and we review homicides from time to time as far as when people have complaints of how the police departments investigated them.
Can you describe what your role is in this case right now?
My role is that I'm now the case officer. That began in January of 2011 when the original case officer was elected and ended up leaving the office.
Do you know when the Bureau first became involved in this case?
Would have been when we actually made a case of it. It would have been in January, I want to say January 16th or the 8th of 2008.
Okay. And do you recall how the Bureau got involved in this case?
Yes, I do. What happened is that one of the prosecutors approached me and asked if I would review some information involving this case. Apparently, one of the family members approached that prosecutor. I said I would. When I received some reports from Pleasant Grove Police Department, I ended up assigning that case to an investigator.
And who was that investigator you assigned it to?
That would originally been Sergeant Toby O'Brien.
Did that then change?
Approximately 6 months later, nothing had really been done on that case. Doug Whitney ended up retiring from the Sheriff's Department and was available. I had a previous case I wanted him to work on that he had worked on years ago, and I had asked him to follow up with that case.
Okay. As part of the investigation, did investigators issue subpoenas with respect to cell phone records?
Yes, we did.
Okay. Would that also include records regarding text messaging?
Yes.
Was there an attempt to actually subpoena the substance of those text messages?
There was.
And did you receive anything?
We did not.
Do you know why?
It had been too late. They only keep them for a certain period of time. And so we did not get the actual text messages themselves, just the fact that they had text.
Those were lost by the time subpoenas were issued?
Yes. With that, yes.
So the cell phone companies weren't able to produce that information for you?
Originally in the case when we subpoenaed those, that's correct.
Okay. Are you familiar with triangulation with respect to cell phones, what that means?
What that means is that through triangulation, they can determine in a general area where that phone call or text is being made.
Either received or
Received
sent.
or sent.
Okay. Did you seek information that would assist in that regard?
We did.
And what was the result on that?
Again, had been too long for us to get that information.
Okay. Are you familiar with the MacNeill family home in Pleasant Grove that's been referred to at length during this trial?
I am.
Do you know where that's at?
I do.
And where is that?
I want to say 3058 Mill Creek Drive in Pleasant Grove.
In Pleasant Grove. Have you visited that home?
I have.
And what was the purpose of visiting that home?
I visited it when we did a search warrant there. I have visited it to actually help with taking some measurements, and that's probably sufficient.
Okay. Are you familiar with the Utah State Developmental Center that's been referred to in this case?
I am.
And do you know where that's at?
It is.
Where is that?
Excuse me. I do. I don't have the specific address in my head, but it's just off of North County Boulevard, and I want to say that's in American Fork.
Okay.
And let me just say, it's right by for those that know, the Timpanogos Temple. It's almost adjacent to the LDS Timpanogos Temple.
Okay. Are you familiar with the location of the American Heritage School in American Fork? This is the school that's been referred to as Ada MacNeill's school that she was attending.
Yes, it's directly across the street on North County Boulevard, across the street from the Timpanogos Temple.
Have you visited each of these locations?
I have.
Okay.
You may.
Mr. Robinson, I'm handing you what's been marked as State's Exhibit 55. Do you recognize what that is?
I do. It's a map.
And are you familiar with that map?
I am.
What is it depicting, generally speaking?
It shows where the MacNeill home is, as well as the Utah Developmental Center, and it also shows the American Heritage School.
No, the state offers Exhibit 55.
Any objection?
No objection.
55 is received.
Mr. Robinson, if I could have you mention it shows certain locations that are relevant to this case. If I could have you to step down and point out to the jury approximately the location of the MacNeill home in Pleasant Grove.
The home is approximately right here on Mill Creek Road, and
Can you identify where the Utah State Developmental Center is?
Developmental Center is right here.
Okay. And what about the American Heritage School?
It's right here.
Okay. Did you have occasion to estimate the travel time between the Pleasant Grove home and the Utah State Developmental Center?
I did. Do you want me to sit back down, or do you want me to stay up here?
First off, did you have that opportunity?
I did.
Okay. Can you just show the jury the route that you took in determining that travel time?
Sure. We started over here, went straight down to County Boulevard, North County Boulevard, and then over to the school right here where the administration building is.
Okay. You can retake your seat for that. How many times did you make this trip to try and determine an estimate?
From the MacNeill home to the USDC?
That's correct.
Approximately, 6 times.
6 times? Okay. Did you take it at different speeds?
2 different speeds.
And what were those speeds?
We did one 25 miles an hour, the other one 30 miles an hour.
You know what the speed limit is in that area?
Yes.
Generally?
Yes.
What is that?
Right along here would be 25 miles an hour. Picks up a little bit here, but
Okay, so about 25 miles per hour.
right.
You drove it at that speed. Did you drive it at 30 miles per hour
I
as well?
did.
Did you at one point drive it at 50 miles per hour?
I did.
Okay, so there are 3 different speeds that you did.
Yes, that's correct.
As far as the travel time between those 2 locations, the home and the USDC, At 25 miles per hour, how long did it take you to drive that?
The actual drive, do you want me to give you each of those times?
Sure.
4 minutes, 37 seconds, 0.5. 4 minutes, 52 seconds, 0.4. 4 minutes, 48 seconds. 5 minutes, 10 seconds, 0.6. And 4 minutes, 47 seconds, 0.3. And then
Now, that was at 30 miles per hour.
that was at 30. That's
Okay,
correct.
So those times were at 30. Did you do one at 25 miles per hour?
I did.
And what was the time?
And that was 5 minutes and 39 seconds.
Okay. You mentioned that you did one at 50 miles per hour.
I did.
And how quick were you able to get from the USDC to the home in Pleasant Grove or vice versa?
3 minutes and 7 seconds.
Okay. Do you have the time at which you made these, the 30 miles per hour and the 50 miles per hour? Approximately what time of day was that?
The time on the would have been, let's just say it would have been a Monday, and I started about 11:42 in the morning.
Okay.
There was another time, the sixth time, or it would have been actually the first time that we did it.
Was this the 25 miles per hour?
That's right, and that was on Saturday, October 5th, and that would have been at approximately 12:45 p.m.
Okay. Did you determine a travel time between the developmental center and the American Heritage School, an estimate of that travel time?
Yes.
And could you briefly show to the jury the route that you took on the map?
Yes.
From the developmental center to the...
We just came right out here to the school. Actually, it comes up here and then down.
So there's a road that's not depicted on that map that goes into the
That's
school?
correct. Yeah, it's part of the school.
Okay. And how many times did you make that travel?
4 times.
4 times. And was it at 25 miles per hour approximately?
Yeah, it's hard to get much speed. It's very close.
Very close, okay. Can you give the jury the times on what it took to travel?
Sure. 1 minute, 23 seconds, 0.9. 1 minute, 24 seconds, 0.7. 1 minute, 28 seconds, 0.2. And 1 minute, 23 seconds, 0.4.
Okay. Did you also have occasion to estimate a travel time between the MacNeill home in Pleasant Grove and the American Heritage School in American Fork?
Yes.
And how many times did you make that drive?
Approximately 3 times.
Would you also just step down and just show the jury the travel route that you took from the school to the home?
So we left the school and we just came straight up.
Now, it appears that route may somewhat backtrack. Is there another
That's
route
right.
that you could have
Yeah,
taken?
we could have gone, probably would have been even shorter, come right up here. We decided to get the light.
Okay. Taking that route, what were the times? First of all, how many times did you travel that route again?
I want to say 3. I know I did it more than that, because I know I did it once on October 5th as well. But it took approximately 4 minutes, 29 seconds, 0.3, 4 minutes, 38.4, and 4 minutes, 31.3.
Okay. Your Honor, I will pass the witness.
You may cross.
Hello.
Hi.
Now, in the travel times that you've discussed, that doesn't include the time from exiting the vehicle and going into the developmental center, for example, correct?
That would be correct.
And it doesn't include the walking time of either exiting a vehicle and going into the MacNeill home or leaving the MacNeill home and getting into the vehicle.
That is correct.
And it doesn't include the time of approaching the American Heritage School in order to pick a child up from kindergarten and dealing with congestion in the parking lot at that time of day either.
We didn't have a child, and we didn't, yes.
So your timings are estimates, right?
They're the times that we took to drive back and forth. That's correct.
And you did time walking from the MacNeill home to a car, correct?
I did.
And in time
We
that
did.
at 23.1 seconds?
That's right.
I was with you. That's why you're smiling.
That's correct. You were with me.
So we did it together, didn't we?
We did.
And that was 23.1 seconds, right?
Correct.
And if I have these noted down wrong, I'm sure you'll correct me. So, and then we also timed walking from a car near the front of the parking lot in the developmental center to the administration building where Mr. MacNeill's office would be.
We did.
And we just went to the outside of the office and didn't go inside.
That is correct.
And that was 1 minute and 31 seconds.
That's correct.
Glad I got that down. You know what I mean? Approach.
Go ahead.
Officer Robinson, I'm showing you what's been marked as State's Exhibit 41. And do you recognize this as Mr. MacNeill's phone record log from the developmental center?
That would be his work log.
His work phone?
Yes, that's correct.
His office phone?
Yes,
And you received this in response to a subpoena to the developmental center?
correct.
And on April 11th, there are a number of phone calls, correct?
If you want to show me here.
Yeah, right here. So maybe for clarification, on this exhibit, there's a phone number, 801-763, over on the left-hand column,
Correct.
and that's Mr. MacNeill's office phone number, correct?
I believe it is. I don't have it in my head, so.
Okay. And then the next item on this log is a number.
Okay.
Correct? You see
There
that?
is a number, yes.
And your understanding is that represents in seconds the length of a
I
call?
believe that's correct.
And then after that number in seconds of the length of the call, there is a date.
There is a date.
And then a time representing the time that the call was initiated.
I believe that's accurate.
And then there is a number representing the number that was dialed.
Okay?
Is that your understanding?
That's my understanding.
Okay, just making sure.
Okay.
And on April 11th, 2007, at 11 o'clock, there was a call placed from Mr. MacNeill's office, correct? You see that?
There was a call placed.
And that was for a total of 360 seconds?
That's what it says.
And it's an 800 number that was called.
It is an 800 number.
And in the course of your investigation, you had occasion to figure out what that number was associated with, correct?
Correct. I don't recall what that was, but that's correct. And I've heard it through the week, but yes.
It was, at the time, Quest.
That's correct.
Right, now it's CenturyLink.
Yes.
Right, okay. And you understand that Quest at the time was a phone company providing phone service to households primarily. Is that right?
They do that.
You actually subpoenaed the records,
Yes.
correct? And you obtained Quest records for the MacNeill household.
We did.
And the records that you obtained didn't have a call detail for local calls on it.
That's correct.
And you tried to get, or at least you investigated getting a local call detail.
We did.
Correct? But they wanted $22,000 to do it, and you declined to get it.
I don't recall that, but I do recall there's something. I don't know the amount. I don't recall that, but thank you.
A large amount of money. They wanted a large amount of money to give you call detail, and then you declined to do that. Isn't that correct?
You know, it's a little hazy there. I honestly don't recall.
Okay. In addition to subpoenaing the cell phone records and work records, you also searched a number of Mr. MacNeill's computers, correct?
Not me
office.
Personally. That's correct.
Through the course of the investigation.
Correct.
Right? And in July of 2012, after Mr. MacNeill was released from federal prison, you conducted a wiretap, correct?
That would be accurate.
Objection, relevance?
Well, I don't know. Did it lead to evidence? That's the question.
I'm just asking about the
Is
investigation.
this your case officer?
It is.
Overruled.
Yes.
I think you already answered it, thanks. And you also forensically examined Mr. MacNeill's cell phone, correct? Or
Our
not
office.
you personally, your
Thank
office
you.
did.
Yes.
Thank you, sorry. And you were able to recover text messages and various data on his cell phone back to at least the summer of 2007, correct?
I don't recall how far back, but it was a ways back. It wasn't during the time frame of when all of this
It
happened.
didn't go back to
in
April, did it?
No.
And strike that. You cooperated with the media in relation to their reports in relation to Mr. MacNeill, correct?
I'm not sure what you mean by the question. Did we cooperate with the media? We had requests and we did respond to requests.
Appeared on 2020.
That is correct.
And gave numerous comments to the Deseret News in relation to Mr. MacNeill.
There were comments.
And you had the occasion to interact with the MacNeill daughters, well, Alexis Summers and Rachel MacNeill a number of times, correct?
Yes.
And some of those interactions were recorded in the form of a formal interview, correct?
That would be correct.
Many others were not recorded, correct?
That would be correct.
And you had occasion to discuss information that you were receiving from Ms. Summers with Doug Whitney, correct?
I'm not sure I fully understand that question. Did Doug and I have a conversation? Is that what you're asking?
Yes, you and Doug.
We met, but I had my own caseload. He was the case officer at the time, and so he would, from time to time, update me on what's going on, but I was fully engaged in an entire caseload. I was not involved in that kind of depth until January of 2011.
And after you became more involved in depth, fair to say you had more conversations with Alexis MacNeill?
Yeah, that would be accurate.
And you had occasion to discuss the nature of those conversations with Doug Whitney?
I don't know how many because he was no longer in the office, right? So you'd have to be kind of specific as far as which conversations.
Right. On April 27th of 2011, you sent an email to to Mr. Whitney, correct?
If you want to show me that email, I'd be happy to identify it.
May I approach on?
You may.
Let's see. Okay, I did send him that.
And in that email, you told him that,
Objection, hearsay.
For what purpose is it offered?
would you like me to approach and comment on it?
On hearsay grounds, go ahead.
Mr. Robinson, in 2011, as you became more involved in the case, you indicated that you had more communications with Alexis Summers, correct?
I had direct communication with her. When you say more, I did have direct communication with her.
And as a result of that communication, you found that you were getting a lot of conflicting answers, correct?
So what's the date on that? I'm sorry. April?
April 27, 2011.
Okay. In January, I
And
had...
I'm just asking you, you had concerns about her getting, or about you getting conflicting answers, giving you conflicting answers to questions.
Now, I can answer yes or no, or
No,
I
that's the
can
question.
give it some meat on the bones here.
My question is yes or no?
Okay. Ask the question again, and I'll answer yes or no.
Yes. In April of 2011, you had concerns about getting conflicting answers from questions that you had asked Alexis MacNeill.
I had written that on the email there.
And you indicated that it concerns you.
I'd like to put that into context, but I think I wrote that yes, but you need to understand that in context, counsel.
Okay. My only point is that in April of 2011, it was your belief that the more questions you ask Alexis, the more conflicting answers you got, correct?
When you say it was my belief, that's what I wrote on there. And if you want me to tell you why I wrote that, I'd be happy to do that. If you want me just to answer yes or no, I'll...
I am sure Mr. Greenham is going to follow
Okay.
up with you on that, but my point is only that you expressed a concern about getting conflicting answers.
That's correct.
And in relation to the email, you indicated that concern had something to do with, for example, the laundry.
Yeah, and understanding the whole dynamics, I was still trying to get myself up to speed.
Okay. Just a moment, Your Honor.
You may.
That's all the questions I have.
Thank you. Do you have redirect?
Briefly, Your Honor.
Go ahead.
Mr. Spencer asked you about some contact you've had with the media during
Yes.
the investigation.
Yes.
Why did you have contact with the media?
In actuality, we were the ones contacted, but we were still, at that point, trying to figure out what we had, and we were kind of at a stalemate, and so we were contacted, and once we got an attorney on board set up, we went through that attorney on any contact that we had in any kind of document.
Was there a purpose then for having contact with the media about the investigation?
The purpose was to generate more leads, and that was the key.
You had a number of contacts with Alexis Summers throughout the investigation.
That is correct.
Did you also have contacts with Rachel MacNeill?
I did.
Did your office facilitate interviews with Ada MacNeill
Yes.
and Sabrina MacNeill,
Yes.
Elle MacNeill,
Yes.
Giselle MacNeill?
Yes.
Okay. Did your office facilitate interviews with a number of neighbor witnesses?
Yes.
Okay. And we've heard from a number of witnesses throughout this trial. You've been present here, is that correct?
That is correct.
And your office facilitated those interviews
Yes.
and gathered that information.
Yes.
As a case officer, in a case like this, you're not an eyewitness to the events, is that correct?
That is correct. I wasn't there.
What's your primary purpose and role?
My primary purpose is to be a fact gatherer, to gather information, and then to bundle that up for the prosecution, to have them take a look at it.
Ultimately, you referred this case for prosecution.
Yes.
Okay. Nothing further, Judge.
Nothing further.
Do you have questions for Mr. Whitney? If you do, I'm sorry, Mr. Robinson, if you'll pass them down the row, any? Very good. You may step down. You'll remain under trial subpoena. Next witness, are you ready?
Yes, Your Honor. The state calls Jason Poirier.
Thank you. Would you approach the bench? Ladies and gentlemen, we're now going to recess for the day. I have some legal issues that I need to take care of. Let me tell you what the future holds in terms of the trial. It's anticipated that the state will rest its case tomorrow morning after potentially 2 more witnesses. The defense may then call some witnesses, but we anticipate that the trial will likely conclude not in the 5 weeks that we anticipated, but less time than that. And how much time and the precise schedule I can't tell you, but that gives you some idea of where we're headed. As we recess today, remember my admonition: don't discuss the case amongst yourselves or with anyone else. That includes any subject of the trial with anyone. It's your duty not to do that. It's your duty not to form or express any opinion until the case is finally submitted to you for deliberation. Avoid television, radio, and internet news coverage. Do no research on your own. We'll convene at 8:30 in the morning. Courts, let me just, why don't we start at 9 o'clock? Because I think I will have some housekeeping matters in the morning. 9 o'clock. Thank you. Please be seated. We're back on the record in the state of Utah versus Martin MacNeill. He is present with his counsel. The jury is not present with us. The issue that has arisen is that it's anticipated that Mr. Poirier may exercise his Fifth Amendment right not to incriminate himself as it relates to certain items of impeachment, certain conduct related to impeachment. Specifically, this alleged selling of steroids. I believe potentially the fraudulent obtaining of prescription drugs from Dr. Moore may give rise to that issue, and the Rolex watch scheme that's been referred to. I'd like to make a record of the defense counsel that's here to advise Mr. Poirier. What is your name?
Gonzalez, Your Honor, from the Utah County Public Defender's Office.
Thank you for being here. As we discuss this issue at the bench, my understanding is that Ms. Gonzalez, correct, would be present in court during the course of the defendant's testimony. I think that's appropriate, but I'm uncomfortable with her giving indications to him from back there what he should and shouldn't say. I think he needs to be fully advised of the right, what issues may give rise to his exercising the privilege, and then he has to make the call. I don't want any kind of direction coming from defense counsel in that regard.
Your Honor, on that point, if he reaches a point where he's unsure, would he be allowed to consult?
Would take a recess and he could consult, but he needs, we'll make a complete record of, and I do need to make that record. Ms. Gonzalez, have you had a full and complete opportunity to advise Mr. Poirier of his Fifth Amendment right not to incriminate himself?
I believe I have, Your Honor. I was just advised today about the Rolex watches, the doctor, and the steroid issues. I had no idea of those prior to that, but we spoke briefly about that and not incriminating himself, taking the Fifth Amendment.
Are you satisfied that Mr. Poirier understands that right? Okay, let me have you come up to the podium, both of you, if you would. And again, will you state your appearance for the record?
Barbara Gonzalez from the Utah County Public Defender's Office, representing Mr. Jason Poirier.
And you are Mr. Jason Poirier?
Jason Maurice Poirier, yes.
Thank you. Mr. Poirier, have you had the opportunity to speak with Ms. Gonzalez regarding your Fifth Amendment right not to incriminate yourself? Do you understand that right? Do you need any more time with her before you would give testimony in this case?
No.
Are you under the influence of alcohol, drugs, or prescription medication at this time? Do you feel like you're in a state of mind where you could make a voluntary choice about exercising that privilege or not? Let me ask that question again. Are you sick or ill today?
No, sir.
No? Do you feel like you're in a state of mind to where you can make important decisions?
Yes, Your Honor.
Nothing would impair your judgment today? I will order that you remain drug and alcohol free between now and tomorrow morning when you would testify, so that you remain in that same state of mind. Do you have any questions for me about that? Thank you. Is there any further record you would want to make?
No, Your Honor, I believe that's all.
All right. Thank you. Mr. Poirier, if you'll be seated, and thank you, Ms. Gonzalez. Will you be available tomorrow during Mr. Poirier's testimony?
Yes, I will.
Thank you. The issue that has been raised by the defense is whether or not Mr. Poirier may testify at all if he intends to exercise his Fifth Amendment right when it comes to impeachment evidence. Defense counsel has indicated an understanding that he would be completely unavailable. I'm skeptical that he would be completely unavailable if that there's a bright line rule that any time a testifying witness takes the Fifth Amendment during cross-examination, he becomes constitutionally unavailable for purposes of the Confrontation Clause. I don't think that that's the rule, but this is a big issue in this case, and I need help. And so I welcome your educating me about this issue. I think we probably need to recess today to allow you to do that research. I will research this issue on my own as well. And let's convene early tomorrow. I've got the jury coming at 9. I'd like to be here at 8:15 for argument on this issue, and then I will rule before Mr. Poirier takes the stand.
Your Honor, may be heard on a starting point for the law.
Yeah, go ahead.
Mr. P just reminded me, and that, I don't know if it speaks necessarily to the Confrontation Clause, but it seems to assume Rule 608 subsection B indicates that by testifying on another matter, a witness does not waive any privilege against self-incrimination for testimony that relates only to the witness's character for truthfulness. And I think that, as a starting point anyway, implies that that Mr. Poirier's intended course of conduct is allowed.
Okay, thank you. And I will certainly look at that. I think you're right about that. 608B is a place to begin. Anything further today?
Your Honor, just for clarifications, we have potentially 3 witnesses rather than 2 tomorrow.
Yeah.
Jason Poirier, inmate number 1, and Gypsy Willis.
Yeah, and Mr. Perkins mentioned that there was some possibility. Have you made a call on that at this point, or
Yes, I think there will be 3 witnesses.
pretty confident on that? How long do you think you'll be with her?
Half hour probably. Is all.
Okay, and Mr. Poirier?
Direct, Your Honor, will be fairly brief, 20 to 30 minutes, but I'm not sure about cross.
Okay, and
I would say about the same, at maximum for Mr.
with inmate 1? Okay. That's helpful. Counsel, I appreciate your work today. Thank you very much. Anything else?
Did Your Honor have a chance to look at Mr. Spencer's response to my motion to reconsider?
I haven't. I will read that and rule on that in the morning as well. Do you anticipate a reply, or?
I don't, and I move to submit it at this point.
Very good. Thank you.